Hello and welcome to Season 2, Episode 4 of ARBinBRIEF. My name is Ibukunoluwa Owa and I'm a member of the ARBinBRIEF team. And I have the pleasure of moderating this episode of ARBinBRIEF. ARBinBRIEF is produced in collaboration with Delos and Arbitration Pledge, and Season 2 is sponsored and supported by LaLive. Today, we'll be speaking about illegally obtained and falsified evidence, and our speakers today will be shedding light on this topic. Our speakers today are Brenda Horrigan and Olga Hamama. Brenda Horrigan is a US qualified lawyer and an independent arbitrator based in Singapore. Olga Hamama is an international dispute resolution lawyer who works as a special counsel with 𝗔𝗥𝗕𝗙𝗏, Germany. Thank you both for joining us and speaking with us today. So we'll start off today with the basics. And my first question will be directed to Ms. Brenda. Hi, Brenda. Please, can you tell us what is illegally obtained evidence? What does it mean to illegally obtain evidence? And can you please give us one or two examples in your explanation?
Sure. There's really a broad spectrum of documents or evidence that falls into this category. It can be everything from documents that were stolen by a former employee as they were leaving a business, eavesdropping or spying. The infamous Australia East Timor case is an example of that, to cyber hacking, malware insertions, other forms of corporate espionage where you're really stealing business secrets.
Thank you very much, Brenda, for that overview on illegally obtained evidence. Now that we have an idea of what illegally obtained evidence entails, it would be great to know what sort of laws govern and regulate it. So my next question is for Olga. Olga, can you please tell us what are the laws and rules that generally govern the admissibility of illegally obtained evidence in international arbitration?
Thank you very much, Ibukun, and thank you for having me. I would advocate a so-called four-step approach when trying to resolve this issue. First of all, I would direct everyone to consult the arbitration agreement. Usually you won't find any specific language with regards to this peculiar matter, but what you will be able to find, hopefully, are applicable procedural regulations and law at the seat of arbitration, or at least seat of arbitration, which will direct you to the law. So the second step would be to have a look at the applicable procedural rules. And usually those would grant actually very broad powers to arbitral tribunal when it comes to evidentiary matters. So just to give you a couple of examples, for example, Rule 12.2 of Delos arbitration rules reads as follows: the tribunal shall have the power to determine all procedural and evidentiary matters. The parties are encouraged to agree on joint proposal on procedural and evidentiary matters for consideration of the tribunal. You will find, for example, more specific language addressing illegally obtained evidence in the IBA rules, Article 9.3. Of the regulation, stating that the arbitral tribunal may, at the request of a party or on its own motion, exclude evidence obtained illegally. So as you see, again, you will see broad powers usually, and as a support in dealing with this broad discretion, I would then, in a third step, advise you to have a look at the regulations at the seat of arbitration. For the purposes of today's discussion, for example, I would like to draw your attention to Switzerland. So first of all, Article 192, paragraph 2E, for example, of Private International Law Act recognizes that an an award might be violating public policy in case of violation of procedural law. And admissibility of illegally obtained evidence is actually indeed recognized as Swiss procedural law. You will find mentions of illegally obtained evidence in the federal constitution. It's also, deemed to be, because it is deemed to be intrinsic part of the right for fair trial. Domestic regulations, such as Article 152, paragraph 2 of the Swiss Procedural Code, in the next step, provide more detailed guidance on this issue. Specifically, the regulation states illegally obtained evidence shall be considered only if there is an overriding interest in finding the truth. So the fourth and last step would be to apply this broad principle to the specific facts of the case. And in this regard, it's also always useful to consult applicable case law, which has been established in this context.
Thank you very much, Olga, for that answer. From what you're saying, it shows that you have to consider procedural rules of whatever country and the law of the state that is being considered in the arbitration when considering legally obtained evidence. But the IBA rules also helps to provide specific rules in relation to that. That is very helpful. Now that we have an idea of what illegally obtained evidence is and the sort of laws that you would consider would govern it, Brenda, can you please tell us, as an arbitrator, how are you usually alerted to the existence of potentially illegally obtained evidence? Is this something that, as an arbitrator, you can raise on your own, or is it something that the parties can and should raise on their own?
It really would usually come up through the parties. They're closest to the evidence. They're most likely to know that something that is in the hands of the other side probably should not be in the hands of the other side. So it's most common that the parties will raise this to the tribunal and then make arguments as to what the tribunal should do. It is possible for the tribunal to identify and raise questions on this issue on its own, particularly if there are documents that are coming in that are clearly commercially sensitive, and there are questions as to how how those documents came into a party's possession. But usually it will be the parties that will be raising these issues first.
All right, thank you very much. Now we would proceed to another class of questionable evidence, which is falsified or manipulated documents. And my first question will be directed to both Brenda and Olga. Olga, please feel free to answer first, and then Brenda can follow. What kind of fraud or falsified manipulated documents have you encountered in your practice? And what kind of evidence is usually adduced to establish that these documents have been fraud, falsified, or manipulated?
Sure. So in my personal practice, the examples of falsified or illegally obtained evidence included, for example, backdated documents. These would be documents where like signatures or stamps would be, put to backdate a specific documents, put onto the documents. So in these cases, usually it's very helpful to work with forensic experts, specifically with ink experts in this specific case. Sometimes it's also helpful to inspect the quality of the paper. If it is, for example, a document that has been printed by a fax machine, which probably we will see less and less in the future, there are also specific experts that deal with specific printing, ink, and also technology that might or might not have existed at a specific time. I've also seen many documents which would be obtained, for example, by illegally initiated don rates, or even if parties would abuse criminal investigation proceedings, sometimes in some jurisdictions, even in collaboration with state authorities, to obtain access to the documents they normally would not have obtained access to.
Thank you very much. Brenda?
Sure, I'd add to those categories also second or third or fourth sets of books. So sometimes you'll find companies that keep alternate financial records for purposes of submission, documents that were created for the purposes of the arbitration. So documents that didn't exist at the time the dispute arose, but were simply created thereafter to create an evidence trail. But also documents that were created at the before the dispute arose, but were created without the proper authorization. You see this commonly in loan agreements, for example, that didn't obtain the proper board authorization that was required by corporate regulations. So you really see again, a broad spectrum. Increasingly, you're seeing manipulated data chains, so email chains where either dates or contents are altered after the fact. And I think we're going to be seeing increasingly the need for forensic examination of metadata as we're looking to determine whether something was actually created at the time. So we're kind of moving away from the ink and paper analysis and toward more technical analysis. But ink and paper is still going to be relevant as well.
Thank you very much, both, for your wide and detailed answers. I particularly like the fact that you highlighted, the use of data, because that's something that is really big now with the use of technology, and how this can sort of expand on forged and falsified documents. That's really good, and it sort of ties into the next question. Olga, please, can you explain to us how an arbitrator should deal with documents that have been put before them that they suspect to have been forged, falsified, or manipulated as a matter of procedure? Is this something that they should raise on their own? And can you also sort of explain to us if any issues of potential corruption would be considered in this?
Yes, absolutely. So as we've seen before, usually arbitral tribunal enjoys great discretion and broad powers when it comes to handling the procedural issues of the case. That would mean that arbitral tribunal is empowered to make its own taking of evidence, but also to raise concern if such are granted with regards to legality or authenticity of certain documents. Well, now, depending, of course, on the degree of concerns of the arbitral tribunal, I think in practice there are various ways to do this. There is a possibility to ask parties if there are any concerns from their sides, to ask them to comment on specific issues, or really to raise specifically, a concern of falsification of certain documents. Of course, there is also an opportunity, if there is a valid and based concern of illegality of documents, to notify criminal investigation authorities, for example, at the seat of arbitration. This is something, in my personal experience, I've seen only once in my life, where arbitral tribunal actually indeed reached out to investigation authorities at the seat of arbitration in context with potential criminal actions of the parties. Otherwise, if at all, it would be usually the opposing party to bring who would bring this up.
Thank you very much, Olga. Brenda, the next question is directed to you. How should arbitrators weigh the evidence that may be forged, falsified, or manipulated?
Again, I think we have to recognize that these circumstances appear on a spectrum. So it's going to depend in part on how serious and significant the extent of the forgery or the falsification is. If it's a single document presented by a single witness, that might go to the credibility of that witness. If it's a number of documents, or basically a category of documents that is supporting a key element in a party's case, it may go to the credibility of the party's argument in its entirety. So it's really a question, again, of how where the document or where the evidence falls on that spectrum. But it can be anything from simply resulting in diminished credibility of a witness to adverse inferences by the tribunal as to the whole nature of a party's case.
Thank you very much. From what you said, that seems to be something that may become case specific regarding on how the documents are forged and falsified. That's good to know. So the next question is directed at both Olga and Brenda. We just wanted to know, what would you say is the general trend in international arbitration now regarding the admissibility of, this questionable evidence that's illegally obtained, falsified, forged, or manipulated? Anyone can please feel free to go first.
Maybe just very briefly from my side, I think so. In my opinion, I haven't been around for so long, but at least like within the last 14 years, that I've been a member of this community, I've seen more and more sophisticated case law which has been rendered in this context. So I think we have a lot of clarity, at least depending on jurisdiction, but also consensus in a way with regards to the approach of how to handle illegally obtained evidence or falsified documents in international arbitration. Going forward, I do think, as Brenda already mentioned, we will see more and more technology being involved in these matters. I assume, we will be also reviewing such issues as potential deepfakes when it comes to video evidence. So this is something we should be embraced for.
Thank you very much.
Yeah, I agree with everything that Olga has said, and I would simply add that one of the other trends that I think we're seeing, along with increased regulation and awareness of this issue, is an increased degree of, let's call it, backbone on the part of tribunals in standing up to this this type of abuse of the process and refusing to allow it to continue. So I do think that tribunals are being more proactive and taking a harsher view than they might have in the past.
Thank you very much. I also agree. Thank you very much, Brenda and Olga, for this excellent discussion. We would like to thank our partner organizations, Delos and Arbitration Pledge, for all their wonderful and all the other wonderful institutions that kindly supported this episode. Delos Dispute Resolution is an independent arbitral institution established in 2014, and Arbitration Pledge establishes concrete and actionable steps to increase the number of women appointed as arbitrators with the ultimate goal of full parity. Our sponsor for second season is Lalive, which is an international firm in Geneva, renowned for its expertise and experience. To see future episodes of ARBinBRIEF, please follow us on our LinkedIn page, like and subscribe to our YouTube page. We would love to hear your comments and feedback. And you can also register for future episodes on www.arbinbrief.com.